Greetings, friends. Welcome back. I am the Lincoln Lawyer coming to you from the COVID-infested lands and waters of Fort Lauderdale. And remember, watch out for those damn zombies. You gotta shoot them in the head or they don't go down. Alright, today we've got a very important topic for you. We're going to chat about the parole evidence rule. This is actually more important than the force majeure clause that we covered earlier, because obviously how often are you going to have a catastrophe occur during your contract? It's not very frequent, but disputes as to contracts are extremely common. So this is the parole evidence rule. What are we talking about? This rule during a dispute about a contract prohibits any of the parties to the contract from introducing outside evidence that contradicts any of the terms of the agreement. Okay, very simple. You cannot introduce any evidence that contradicts any of the terms of the agreement. This is a rule of certainty and finality. It allows planning by the parties, okay? Because if you sign an agreement and then later one of the parties comes back and says, well, we were in the elevator and you told me so and so that I don't have to worry about that, or we were drinking, at a bar and you said, well, forget that provision, I'll do something else. Well, if any party can do that at any time after a signed contract is executed, then contract isn't worth very much, is it? There's no point in signing one. So this rule developed as a form of finality, okay? So notice I said that it prohibits introduction of contradictory evidence. It does not prohibit introduction of evidence that clarifies, explains, elucidates, otherwise makes clearer any of the terms of the contract. Okay, so we're going to look at how a court decides whether to admit outside evidence in a little bit. First of all, we're going to go into how we actually express the parole evidence rule, which is a substantive rule of evidence, how we put it into a contract to make sure that the parties are aware of it and agree to it. So when a contract is signed, there's a presumption of full integration or merger. Okay, that means everything that was talked about, that was agreed upon, was merged and integrated into the paper document, into the contract. Okay, very simple. So the way once a contract is signed, there's a presumption that it's integrated. Now, even without the following clause, you put in a merger or integration clause into the contract, and that says that there are no outside agreements, promises, statements, warranties, representations, promises, agreements, etc. that exist that were not put into the four corners of the document. That's what the merger or integration clause says. It's the same thing. It can be called merger or integration clause. Doesn't matter. So that clause actually strengthens the presumption that the agreement has been integrated, fully integrated. Okay, and getting outside evidence into evidence during a dispute is that much harder with the clause. So your agreement should definitely have that clause in it. Okay, so how does a court decide whether to admit outside evidence? That is done with a sort of a balancing test, which depends on whether the item sought to be introduced is covered in the agreement and its relevance to the subject matter of the agreements. So, for example, let's say something is sought to be introduced by one of the parties and it is fully covered in the agreement, it is not ambiguous, it is clearly covered in the contract, then forget it. It's not coming in. Okay? And another example is, let's say that it is not covered and it is highly relevant. Or it is covered, but it's covered in an ambiguous way. So that means somebody fucked up. Okay, so this is not clear drafting, that it can go either way, it's ambiguous. Alright, so the term is not clear and it's not covered. Then potentially there is a likelihood that that evidence will be allowed in. Okay, and a third possibility is if it's not covered and it's not particularly relevant, then it's highly unlikely that that evidence will be allowed into the dispute. Okay, so very simple. All right, the relevance, how relevant is it, and is whether it's covered in the agreement itself. Okay, so there are a few exceptions to the parole evidence rule, and they're very basic. Basically, fraud, mistake, accident, things like this, they have to be proven by outside evidence because it's not in the agreement. So fraud will obviously void any contract, and accident and mistake need to be proven with sufficient evidence by outside evidence. So that kind of stuff will usually be allowed into evidence. And finally, terms of art, okay, words of art, terms of art, these are words that have an industry-specific meaning that is not the same as commonly understood meaning. It is a specific type of meaning. So generally, the meaning of a term or phrase or word will generally be allowed to be introduced if it is an industry-specific term of art. So that is another exception to the Parole evidence rule. Okay, so that should do it. That should cover the Parole evidence rule. To summarize, this rule prohibits the introduction of contradictory outside evidence into a dispute between the parties to a contract. Okay, it does not prohibit evidence that clarifies, explains, elucidates. Okay, so that's what most of the litigation is about, generally speaking. So you can say anything contradicts and anything clarifies or explains a contract. So that's what most of the litigation on this point is about. Parties saying, yeah, this contradicts, another party says, no, it elucidates. So courts are different, states are different, obviously judges are different. So some states have the Four Corners Doctrine. They have strict interpretation of contracts. They will pretty much only look at the document itself and interpret it as is. They will very rarely allow outside evidence. States like Texas, for example, have a strict construction doctrine, and other states will be more lax. But generally, the way court will review the introduction of outside evidence is by using the balancing test we just went over. It is the relevance to the subject matter and whether it's already covered in the agreement, okay? Because if it's not covered in the agreement and it's highly relevant, well, then it should be generally permitted, okay? Or if it's ambiguous, then it should be permitted. But if it's not relevant and it's not covered, then there's no real reason to actually admit it, okay? And obviously, if it's fully covered, the topic is fully covered, it's not ambiguous, it says A, B, C, that's it, clear, then outside evidence is not coming in. Okay, and then we covered a few exceptions to the Parole evidence rule. So I hope this has been interesting, enlightening, and thank you for watching. I'll see you next time. Stay safe out there. Enjoy your quarantine.